From the hearing in the matter of Elan-Cane.
Yes, good morning, Sir James. Will you just give us a moment to get ourselves organised? Yes, thank you.
My Lord Lloyd Jones is still tapping with mask on.
I'm there. Thank you.
My Lords, my Ladies, our submission is that the judge at first instance and the Court of Appeal were right for essentially the reasons that they gave. And the question for this court, you will need no reminding, is whether they either erred in principle or were wrong. That's the well-established test on appeal for this court. The issue before you involves a positive obligation, and the question whether a positive obligation on the United Kingdom arises. And of course, what a positive obligation means and entails is that the state must take action in the sphere of dealings between private individuals inter se or private individuals and the state. Or put it another way, in a context like this, respect for private life can only be shown by imposing not merely a duty on a state to refrain from taking action, but a positive obligation to do the thing. Hammerleinen, which contains pretty much all of the base principles you will need across the range of issues I will be considering, indicates the preferred route of the Grand Chamber and the preferred initial analysis of the Grand Chamber. 747, paragraph 64, if you would. Picking it up in the third sentence of paragraph 64 on page 747, the Grand Chamber is of the opinion that the question to be determined by the court is whether respect for the applicant's private and family life entails a positive obligation on the state to provide an effective and accessible procedure and so on. The Grand Chamber therefore considers it's more appropriate to analyse the applicant's complaint with regard to the positive aspect of Article 8. So they're taking a different initial analytical route to the route which the Chamber below had taken. And of course, if a positive obligation is imposed, that implies that there is only one way of according respect. And that is a high thing. It's a high thing because if that is the conclusion, it means or implies that all countries signed up to the European Convention, so all countries in the Council of Europe, without an X in the passport, are in breach. And if that is the conclusion, it has to be a conclusion that that step, which is the subject of this challenge, X in the passport, needs to be taken immediately. There is a current obligation, a current positive obligation. So the question ultimately then is how does one analyse whether such a positive obligation has arisen? And again, we see the base principles set out in paragraphs 65 through to 67 in particular of the Grand Chamber and Hammerleinen. I'm not going to read them out, they'll be very familiar, but those are the passages from the Grand Chamber setting out the basic principled approach. And as you will have seen already from those passages, essentially the analysis is factorial. The factors that are identified shape the approach to the question whether a positive obligation is imposed or not. And given the intertwining, they are analysed in particular by reference to the margin afforded to states. But that is in essence, as all the cases indicate, in effect a margin not to do the thing which the positive obligation would otherwise require. So the punchline for the European Court of Human Rights is always to say there is no positive obligation, if that's their conclusion, and therefore this step, it is asserted that the states should take, is within their margin, effectively. That's the way in which the analysis works out. So, flowing from that, the existence of a positive obligation and the extent of the margin are, at the very least in this context, intimately intertwined. And it's no answer, therefore, to the analysis which Hämäläinen in the Grand Chamber enjoins for the appellant in this case to say, including, as I say, with the consensus of states at the heart of the analysis, it's no answer to say, well, consensus is to do with margin, and margin is an analytical approach, not a factor. So it is, but you see how the analysis works from those 3 paragraphs in Hämäläinen. And there are 4 particular factors that are identified that are going to shape the structure of my submissions to you today, all of which are evident from those paragraphs in Hämäläinen. Are there sensitive moral or social issues involved? Is there a consensus amongst Council of Europe states in particular? What about the public interest? And what about the private interest?
I'm sorry, could you give us those again?
Yes, my lord. They're sensitive moral/social issues, 1. 2, consensus amongst Council of Europe states in particular. 3, public interest and factors affecting the public interest. And 4, private interest, nature of right or interest involved, extent of prejudice and so on. So there are 4 of those, and one sees those themes reflected in the development of the case law relating in particular to trans people in their acquired gender. And what the case law overall tends to indicate, unsurprisingly given the nature of a positive obligation and its imposition, is a cautious development by the European Court towards limited recognition and specific types of recognition or forms of recognition based only on a solid consensus amongst the legal systems of member states, testing, therefore, the social, moral, legal controversy and seeing whether it's reached a point of solidity sufficient to impose the obligation. That's the essential overarching analysis. And having done that analysis, or as part of the central to the ultimate question they ask themselves, they take into account those factors. The ultimate question being, as they point out in Hämäläinen at paragraph 65, whether or not at the particular point in time the relevant state has struck a fair balance. So those factors feed into that question of fair balance. And as I say, I'm going to structure my submissions, if I may, by reference to those 4 heads, coming at the end and briefly to the separate domestic constitutional question, which is who is the right primary constitutional actor under our system. But before I take them in turn, if I may, I wanted to do 2 initial things. The first of them is to take you to the recent judgment of the Supreme Court, a 7-person Supreme Court in SC. And I'm going to take this relatively quickly because I know it will be familiar to at least 3 members of the court, probably to the other 2 as well, but for my ladies who weren't part of the composition at least, it may be worth just looking at this briefly. And I go there principally for this reason, because you will see when you get to Hämäläinen and its factors just how close the chime is between the analysis of the Supreme Court there in the context of an A8/A14 case, but how close the analysis is and the balancing of the factors and the way that they interrelate. You will see that this analysis in Hämäläinen in our specific context looks very, very close indeed, we respectfully submit, to the nature and form and structure of the analysis, particularly in relation to margin, of the Supreme Court in SC. This was about benefits for families who had more than 2 children, you'll recall, so there was a challenge to that, but the context doesn't perhaps matter so much. Well, I'm going to it for the nature of the principled approach, and in particular, how the different factors that feed into the margin analysis, and those factors being sometimes in tension, how that tension is to be resolved, and the closely related question here, with exactly the same thinking in Hammerline, and particularly at paragraph 67, whether it's appropriate to impose a positive obligation on a state to take a particular specific step. And as I say, my overarching submission at this stage is that much of the thinking and the conclusions in the context of margin in SC works equally and is equally applicable to the set of issues that confront the court here. I wanted to pick it up for the purpose of that point, if I may, at paragraph 98. And the key section, and it's a long section of analysis on the vexed question of manifestly without reasonable foundation, and whether that survives and what it means. But it's a much broader analysis than that. It goes to work out how you balance the sort of factors that regularly feed into margin of appreciation in the Strasbourg context, and how particularly does one resolve the issue when those factors are in tension. That's the nature of the analysis. So 98 and following, or 98 to 142, that whole section I would respectfully recommend. I'm certainly not going to read out all of the various bits of that, but I recommend it to those members of the court who weren't part of the composition and won't be therefore necessarily intimately familiar with it. What I was really going to do was just to invite you to sideline, by way of emphasis, some of the paragraphs as containing the core reasoning and conclusions of the court in that case. And it starts at paragraph 99 in terms of the essence of the reasoning, noting that the court hadn't provided, that's the Strasbourg court, hadn't provided a systemic analysis of the relevant factors and how they interact. And then the basic theme of the analysis that comes is in the penultimate sentence of para 99, it might be thought. It's more useful to think of there being a range of factors which tend to heighten or lower the intensity of review. In any given case, a number of these factors may be present, possibly pulling in different directions, and the court has to take them all into account in order to make an overall assessment. So that's, as it were, the step forward. You'll recall that in the context of manifestly without reasonable foundation, there was some temptation to treat it as a test. And ultimately, the court's reasoning in this case was to say, no, you don't treat it as a test. You work out and weigh the different factors that may be in play for the purpose of determining what particular margin is to be accorded in any particular context. And then at 100, the court starts with the ground of the difference in treatment. Well, that directly corresponds to the factor in 67 of Hammerleinen, the first of the factors there mentioned. And you'll see the references there to suspect grounds of discrimination and the various distinctions that flow from that. And the court notes, by way of caution, that not merely is this, at the back end of paragraph 100, that not merely is the suspect ground a somewhat fluid category, but also, see the final sentence, a much less intense review may be applied even in relation to some so-called suspect grounds where other factors are present which render a strict approach inappropriate. So one doesn't just jump, as indeed the Grand Chamber's analysis at para 67 of Hammerleinen doesn't jump. You don't just jump from the involvement of a suspect category to a conclusion that the margin is narrow. That is antithetical to the analysis of the Supreme Court in this section of the SC judgment. And the reason for that, and the way that the case law has developed to support that, is then the subject of intensive analysis by the court by reference to a succession of Strasbourg cases, analysing how the margin has worked in practice in those cases and then seeking to draw conclusions from them. You'll note in particular, as we track through 102, first sentence, picking it up in the third line, court has found no violation where a state has been acting to correct a historical inequality between the sexes, and the pace of change has been reasonable in the context of the contracting states as a whole, at least some echo here. And then initial conclusions at 103, I can just invite you to read perhaps the whole of 103. So we're so far on the very weighty reasons for a suspect category type case, and then the court tracks through the analysis by reference to the additional cases cited in 104, 105 and 106. Comes to sexual orientation at 107 and makes the point, in essence, that although sexual orientation is one of those grounds that has been identified as requiring particularly serious reasons, as the court says in the second sentence of 107, nevertheless, a relatively wide margin was allowed in Schalk and so on. And then can I invite you to read 107 as one of the key paragraphs in the stepping stone of the reasoning. As you'll see, that paragraph illustrates two themes, perhaps. First of all, that balance point that I've made already. Even if you've got a suspect category or very weighty reasons needed, nevertheless, there may be other factors present pushing towards a greater latitude. See in particular the analysis of Petrovich at the back end of that paragraph, but also the significance in terms of the analysis of consensus, as one sees about two-thirds of the way through 107. Then further analysis of the case law at 108, 109, and a case which the court, unsurprisingly perhaps given the range of issues that were involved in the illustration, it provided some analysis in particular in detail of the Iwida case at 110 to 111. But then pulling things together, 115 is a key paragraph because that paragraph sets out the court's analysis and conclusions drawn from the detailed analysis of the case law that has been conducted in the previous paragraphs. Can I invite you to cast an eye down 115? So placing the strict justification in context at sub 1, but then recognising there may be other factors that push the other way, including where issues involve economic or social strategy, see the fourth line of sub 2. Noting in the third point that the margin can be affected to a considerable extent by the existence or absence of common standards amongst the contracting states, and then historical inequality over a transitional period and evolving rights in sub 4. And picking up in particular the third and fourth points, just to jump forward to 119, noting that in Steck, the famous Steck case, the third and the fourth points were particularly in play. And then continuing the analysis on into 120. And again, 129, if I may, 129 was really the penultimate paragraph in this section, which runs all the way up to 142 that I wanted to touch on, because it, again, a bit like 115, is a conclusions paragraph from the analysis of the case law that has preceded that, and effectively concluding that the case law that has been analysed after 115 is effectively consistent with and confirms the initial conclusions that the court had reached in 115 about how margin operates. And the reason for the structure in that way was because obviously that case concerned social security benefits. And so they were seeing how those principles applied in the social security context, and the answer is they applied in the same way. Our respectful submission is that Hammerleinen, in our context, demonstrates that you have substantially the same approach being adopted, perhaps unsurprisingly, given the principled nature of it, in the context of the imposition of positive obligations. Then finally, in this context, 142, to jump all the way forward to the end, if I may. Again, a genuinely concluding paragraph, because this is the last paragraph in this little section. 142, pulling together some of the themes analysed earlier. So I hope that's a helpful summary. It'll be very familiar, as I say, to three members of the court, but just to show you that analysis as to how it works, the punchline for our purpose being that one sees, in effect, exactly the same approach being adopted in Hammerleinen, in particular in Para 67. That's the first initial point I wanted to deal with, just to refer you to SC and remind you of the Supreme Court's intensive analysis and reasoning in that case of how margin works generally. I wanted then, as the second initial point, briefly to deal with the domestic approach to margin and to make a number of points in relation to that, if I may. The first of them is that there is evidently, in principle, a difference in the basis for margin if you are considering the matter from the perspective of Strasbourg and therefore on the international plane as compared to considering margin or its equivalents on the domestic plane. But it's equally clear from the case law that the concepts applied by Strasbourg and domestically under our HRA case law, the concepts are analogous. And that is unsurprising. You are asking, essentially, as courts, similar questions about which constitutional actor, if that concept can be dragged into the international plane as well, should be the primary decision maker and the extent of respect that is to be accorded to that primacy. So you're asking essentially similar principled questions. And if, for example, therefore, there are different difficult and controversial issues, socially, morally, legally, even economically, on which there is no clear consensus, then the courts have traditionally been, both internationally and domestically, very cautious before intervening to impose the positive obligation. Likewise, if there are balances to be struck between different rights and interests, and where you're dealing with the coherence of regimes, both legal and practical. So, although they are evidently different, there are analogies between the two ideas, is the first point.
But just the European Court always retains a supervisory jurisdiction even when there's a margin of appreciation and even when there's a wide margin of appreciation. Does that aspect hold good in this analogy? My lady, I think it does, or at least analogously it does. Because under the Human Rights Act, and it's quite an important point that I'm going to come to when I deal with Re G, where there may be some confusion about how precisely Re G was meant to operate from its inception.
But under the Human Rights Act, as you know, and as has been frequently stressed by this court, the courts are positively enjoined to decide human rights issues. So this isn't about exclusion of the court's jurisdiction. This is about how the court goes about determining compatibility.
Thank you.
My second point was going to be that there's a clear constitutional constraint imposed by the Human Rights Act. And that constitutional constraint is reflected principally in the Ulla principle. And what the Ulla principle does, as you know, is to import a notion of real constitutional caution before moving beyond Strasbourg. And that here, we would note in parentheses, is plainly what you're being invited to do, given the absence of any comparable ECHR case and the consensus position that I will come to. But the position in relation to Ulla and how it works and the nature of that constraint has also been considered in some detail in the recent cases. If you still have open on your screens SC, can I start with that? And I can pick it up, I think, exactly on this page on which I left you, because the approach of the domestic courts is dealt with at 143 to 147 of SC. And you'll note the analogy point that I made earlier in the first sentence of 143. And then there is an examination of the principal basis for the domestic courts generally endeavouring to apply an analogous approach. And the first of them was set out by Lady Hale in Countryside Alliance. It isn't the normal one from Countryside Alliance that is cited, which is normally Lord Bingham about people achieving things through the courtroom that they didn't achieve through the parliamentary process. This is another one from her ladyship, but you'll see the passage which is cited. And so although the nomenclature is different, as was pointed out all those years ago in Kebele, and the concepts are essentially similar, which is the point made after the quotation in 143, and then the second reason, which is quite important when one comes to consider Re G, is at 144, and that's all about the separation of powers. And that's a theme which is then developed in 145, 146 and 147. So that's SC. The point was considered also in, if I can invite you to jump to AB, the second of the Supreme Court judgments handed down last Friday, the AB case. This was about young offenders or juveniles being put into solitary confinement in prison, or young offender institutions, and a unanimous judgment of the Supreme Court. The passages that I particularly wanted for this purpose, because they go to this issue about domestically how it all works, are at 54, powers 54 and following. And these were the passages you were looking at yesterday with my learned friend. And again, I recommend, if I may respectfully do so, the entirety of that section, especially the rationale for the principle identified famously by Lords Bingham and Brown in Elan-Cane, no less, no more, no more, no less. And the conclusion which is drawn starts at, by the Supreme Court in AB, starts really at 57, by noting that what the Ulla principle really does, see the first sentence of paragraph 57, as Lord Brown explained, the intended aim of the Human Rights Act to enable rights and remedies available in Strasbourg also to be asserted and enforced by the domestic courts is particularly at risk of being undermined if domestic courts take the protection of convention rights further than they can be, and then these are the words that I've circled, that they can be fully confident that the European Court would go. If the domestic courts take a conservative approach, it's always open to a person concerned to make the application to the European Court. If it's persuaded to modify its existing approach and so on, and then this in the final sentence. But if domestic courts go further, then they can be, again, the phrase, fully confident that the European Court would go, and the European Court would not, in fact, go so far, then the public authority involved has no right to apply to Strasbourg, and the error made by the domestic courts may remain uncorrected. And what that... I'm sorry.
Well, I was going to say, it strikes me that if you, I mean, this is all based on the rationalisation of what the aim of the Human Rights Act was by Lord Bingham and indeed others in other and later cases, including the ones cited. And that rationale of effectively providing corresponding rights and remedies at the national level to those that would be available at the supranational level has nothing to do with margin of appreciation. And Lord Hoffman's reasoning in Re G that, oh well, Lord Bingham in Allah was only talking about a case where the issue did not fall within the national margin of appreciation, and his remarks should be confined to that context, is actually incompatible with the logic of,
and structure of
Lord Bingham's explanation, and not just his, but Lord Scott in Elan-Cane and Lord Bingham again in the Denby High School case, and so forth.
I respectfully agree, and the logic of that is this is clear, and its principled underpinnings. It is clear. I respectfully agree. I'm going to come to Re G in a moment, if I may. Yeah,
I mean, the starting point is what was the intention of Parliament in enacting the Human Rights Act, which is a question of national law, which has got nothing to do with the international doctrine of margin of appreciation.
I suppose the only echo back into margin of appreciation was the question that my Lord Sales was putting to my learned friend yesterday. If we throw our minds forward, even if you're in a Rabone context, you don't require, says Rabone, an actual case on your actual facts if the principles are clear and you can be relatively or fully confident, to use the phrase, which is why I emphasised it, then you can go there. The difficulty comes when you go beyond that. So if throwing your mind forward Rabone style, I think was the question my Lord was putting to my learned friend yesterday, your conclusion is that what Strasbourg would do in our positive obligation context would be to say margin consensus not yet. Then the answer to that under the Human Rights Act ought to be the same. And if it isn't the same, you've got a constitutional problem under the HRA, as you rightly point out, which is a question of national law, and you've got a problem under the HRA because you're effectively, as my Lord put it graphically yesterday, simply making it up after that. And that's not what Parliament has allowed you to do, applying the rationale in Ulla. So,
I mean, the Rabone approach is fully in line with what my Lord was saying about what the object of the Human Rights Act is. And part of the object is to spare people the long road to Strasbourg to vindicate rights which would be vindicated in Strasbourg. And Rabone says, well, if you know now the right would be vindicated in Strasbourg, vindicate it now.
Well, my Lord, that's why I've understood the court was careful in AB to use the phraseology fully confident twice, as I indicated in 57, but also when it came to analyse the Rabone line of case law in 59, para 59 in particular, used a phrase that is regularly used in terms of the development of the common law, which is incremental development. But again, it's got that notion of confidence. Can you be confident that Strasbourg is going to go there? Of course, if you can, well, then there's no difficulty. You're within the bounds of the Human Rights Act. There's no constitutional problem and everyone moves on.
The basic point is summed up by bringing rights home.
It is. Yes. It is. No more, no less. Lord Bingham would add, or Lord Brown would add if you reverse it. But yes, my lady, you're right. So that's the way in which the court has analysed it in AB, and I respectfully agree with the points that my Lord the President was putting to me earlier about Re G. And if I may respectfully so say, Re G does need a bit of re-evaluation, particularly in the light of the force and reasoning of the court in AB and SC in those two recent cases, including again, if I may respectfully say so, Lord Kerr's treatment of the Re-G principle in Steinfeld. But the broader resolution may be to recognise that, in fact, Re-G has not been followed, or followed in precisely the way, on one reading of it, might be thought to be intended since. And certainly one needs a very clear understanding of the limits of it, not least because when you get into the logic of Re-G, it seems to be premised on a slightly strange assumption. Of course, as I pointed out earlier, there are separate ideas going on the international plane with margin of appreciation and on the domestic plane with the level of respect and caution that is appropriate because of separation of powers questions. But that recognition of the fact that they are different, and I deliberately use that as opposed to distinct, the fact that they are different cannot and does not render OTOs the need to respect the separation of powers, nor all of the subsequent careful analysis of its principled foundation in myriad cases from this court, including institutional competence and democratic accountability. And indeed, that importance of separation of powers, Lord Hoffman would have been horrified if it had been taken as an invitation to ignore that, with the courts just piling in to make their own judgments about these things, because he emphasised time and again the importance of separation of powers in Re-G. So what clearly needs to be recognised is that this isn't about, it goes back to my Lady Arden's question, this isn't about whether the courts have a role or a function in seeing whether there is an interference and deciding, if so, whether it's justified. That mischaracterises the issue and the debate. The courts plainly have that function under the Human Rights Act, as I pointed out. The margin of appreciation in Strasbourg doesn't shut out a domestic examination of the justification issue, nor of a consideration of the breadth properly to be afforded in our domestic context applying separation of powers. The question is how, not whether that function is to be performed. And so recognising that the margin of appreciation as applied by the ECHR doesn't apply domestically, it does not lead on any view, and there are some suggestions in the case law of the court that this might have been thought to be how it does work, but it can't mean and doesn't mean that the court is then simply freed because you utter the words Re-G from the shackles imposed by the separation of powers, or indeed by the common features that would apply in Strasbourg under margin. What it does is at most to indicate that you need to consider in the domestic setting the appropriate degree of respect and caution that is to be afforded under our domestic principles. And indeed that, we respectfully submit, is exactly what Lord Hoffman recognised. I'm not going to invite you to go back to it, but if and when you go back to it you get to paragraph 37 in his judgment, the absolute key to this analysis, we respectfully submit, is the adverb. And the adverb is automatically. But we respectfully submit that the true analysis and the true principle basis and its consequences are now super clearly set out in the two, now as it were binding, the two judgments that the court handed down after extensive consideration, both on a similar theme on this issue in SC and AB. My lords, my ladies, those were the two initial points, which I hope have been helpful at the beginning. I was going to move to the various factors that apply in our context for our positive obligation, or asserted positive obligation. And the first of them is whether or not we are dealing here with sensitive, moral, or ethical, or even legal issues. Are we in that territory? And our submission is that we plainly are, and the Court of Appeal and the judge below were right so to hold. We're in a position in which society and its values and its attitudes are developing. We're in the area of evolving rights, as is patently clear, intertwined with the question whether those values have effect is the question of timing and whether there is an obligation now or whether the societal position is still in a state of transition. And that in itself, and as an overarching question, raises all sorts of sensitive and difficult moral, ethical and legal issues. We are still in a state of transition and development in terms of how societies approach these issues, both at a general and at a specific level. That's what I mean by evolving rights. But there are also a series, and one can take this at any level of specificity one chooses, there are a series of associated issues that would need to be considered and dealt with, which themselves raise those sorts of issues. What preconditions, if any, before a person can take advantage of X on the passport? What preconditions, if any, before a particular form of recognition is accorded to a non-binary person? Is it mere self-identification? Is more required? Is more required for one context or another context, one form of recognition or another? Then all of the issues to which I will come about wider impacts, the impact on systems of law that are set up currently on the MF basis. And those, of course, are issues, which is why it feeds into margin this, on which the court is not well cited. It is not the best constitutional actor because of the breadth of vision that is afforded to other constitutional actors in this sphere. My learned friend, Miss Gallifant, denies, perhaps somewhat to the astonishment of some members of the court, that we are actually in this territory at all. That's a surprising position, we respectfully submit, and not really a tenable one. But it is to be noted that the device for the denial was very narrow. It was put on the basis that we're not in that territory because putting X on the passport is neutral and so does not necessarily raise any issues about third gender recognition. Well, a number of things, perhaps two or three things to say about that. The first of them is that there is, in the use of that device and its narrowness, implicit acknowledgement of the thoroughgoing controversy that would be in play if those issues were themselves in play. And that implicit acknowledgement must be correct and poses real difficulties for her case. But secondly, this device is a bit like the one that says, just look at all this in isolation from any other consequences, because you don't necessarily then have to grapple with those consequences and the social issues and the difficult issues that they give rise to. This is just a slightly different type of device to get round with having to grapple with those problems, but that's not a luxury which is afforded to a state. In any event, there are serious social and other issues involved with making X on the passport a pure choice thing. And that's the premise for this device. Serious social issues even with that.
Just an easy example, could somebody then come to the border and present a passport with an X in it and thereby make life very difficult for the authorities to know whether this was a false passport or not?
My lady, they could, and I'm going to come back to that as a separate head under security. My point at this stage is the more limited one, which is that there are just difficulties in trying to work out whether that's the right or the wrong answer as a matter of policy. Do you want X to be a pure choice thing? All I need to do at the moment is to establish the existence of issues associated with that. But perhaps most fundamentally, and the final point in answer to the device for trying to narrow the denial to get one out of the difficulty of the social issues that would otherwise arise, the most fundamental difficulty my learned friend faces is that that way of looking at things and that submission and that device effectively uncouples the boat from the engine. It's perfectly clear that social issues are associated and would be associated with third gender recognition. That's what's driving the change on her case. Otherwise, there's no need for anything. It's just a matter of pure choice. So the problems that exist with trying to deny that this is a context which deals with social sensitive social, moral and ethical issues, it's a very, very difficult submission we submit. And our positive submission is, of course, at any number of different levels, those sorts of issues are squarely engaged.
I was wondering whether one might say that going down what you've described as the device takes one further away from whether it's a suspect category or not. Because if it's a pure matter of choice, anyone could choose X, but anyone isn't a suspect.
Anyone isn't a suspect category at all.
Category in themselves.
Yeah.
Anyway.
Oh, well, yes, if I'm allowed to say that too. Anyway, that's the first of the factors, and has been taken, can be taken relatively shortly. Consensus is the second of them. And I wanted to break this down into principle and application, two segments to this set of submissions. So far as principle is concerned, the first point to note is that the difficult, sensitive, moral, ethical, legal and all the other type of issues, i.e. my point one, is why point two, i.e. consensus, is so important. The central question under consensus is as to the state of evolution of societal values as reflected in state practice. And it asks, is there clear evidence, brackets, in relation to the specific alleged obligation of, quote, consensus? The quote for consensus being from Hämäläinen, paragraph 67, which uses that word. And I would add, to finish that question, in other member states.
Is it unusual for Strasbourg to rely on international consensus when no European consensus exists?
My lady, it was the extreme example posed yesterday. That would be a deeply peculiar position in principle. I'm going to come to address that directly, but my submission is it would lead to the absurdity in which Council of Europe states have, let's say, unanimity about a particular vexed social issue, but there is full-blown development outside the Council of Europe.
Yes.
And that feels like a very odd bit of analysis.
I couldn't think of another example, but
I can't think of another example. I mean, they have sometimes referred to and relied upon, as you know, lots of other international instruments, and I'll come to that in due course.
Well, I can give you an example. In the Privy Council, we recently heard two cases concerned with whether same-sex marriage was a right guaranteed by the constitutions of some countries in the Caribbean.
Yes.
And it was apparent, it's an extremely vexed question there, because of it's a very different culture from the culture of North America or Western Europe.
Yeah. Well, that's the principal basis for focusing on C of E countries. So what this central question is designed to do when addressing consensus, and the reason why it's important and why it lies at the heart of the analysis of the Strasbourg Court, is because different systems, or the state of development in different systems and the social and legal position, is a very powerful factor against there being, under the ECHR system, a positive obligation as integral to according respect for private life. The principal basis, to come to that directly, given the questions the Court's just asked, is that Council of Europe states have signed up to the ECHR. Let's go back to absolute basics. And for that reason alone, state practice amongst the parties to the treaty in question is, under traditional international legal principles, central. But if one looks at it rather more broadly, the fact that there are differences between states is significant, because under the ECHR system and its jurisprudence, the flip side of differences between states on a vexed issue is that the ECHR does not impose solutions, but allows for differences, especially in the area of evolving social and legal thinking. And the basic principles underpinning the ECHR do not feature uniformity of pace of development as a feature. It's for states to decide until that clear movement has occurred, until the solidity has been reached. And that, of course, explains the cautious nature that one sees from the case law of the European Court's approach to the imposition of positive obligations, cautious as to the recognition of status, and even when that is done, still cautious as to the incidence of recognition. That begs a question which the Court of Appeal became very interested in, partly because it was a deep and interesting philosophical question, which is, what does the case law tell us about what consensus is? How does consensus work? I'm not going to spend a lot of time on that. We've set out in paragraph 51 of the case, if I can just, perhaps it will be as well just to show you it, we've set out our attempt to assist, at least with practical examples from the case law, to assist with that question. So para 51 of the case. And again, this is, of course, no more than a flavour, but these are illustrations as to the sorts of numbers that have swayed the European Court and not. So it doesn't answer the deep philosophical question, but it provides at least some working examples of how that principle operates in practice. And I'll come to the application of the principle in a moment, but I'm still on the principles of how this works. That at least gives one some flavour, that paragraph, I hope, helpfully, of the sorts of numbers that do and don't impact. I said earlier, when describing the central question, whether there's clear evidence in relation to the alleged obligation of a consensus in other member states, I said in relation to the obligation in question. And I said that because paragraph 67 of Hämäläinen makes clear that a lack of consensus indicates a wide margin for states or a deep improbability of imposing a positive obligation, whether that lack is either, as they put it, and I'll quote for the rest of this, is either in relation to the relative importance of the interests at stake or as to the best means of protecting it. That's the language they use in para 67 of Hämäläinen, and what that indicates is that positive obligations can exist at a higher or lower level of specificity. There may be particular legal ways of protecting the interest concerned as to the form of recognition or a particular legal obligation asserted as a precondition to respect. So the question is there consensus as to the step it is said that the state is positively obliged to take? And that goes to my learned friend's forensic choice of target, having selected X in the passport.
What's the analysis? So taking gay rights, for example, one would say there's definitely a consensus that it shouldn't be illegal, homosexuality, but you would say not yet a consensus for marriage. So there's a sort of bundle of rights arising from the engagement of Article 8. But how would you express the absence of a right to marriage? It's obviously not to do with Article 8 not being engaged. Does it mean there's no interference with the rights because the right hasn't, that incidence of the right hasn't arisen? Or I'm not quite sure what step in the chain of reasoning that analysis comes in.
My lady, I think my answer to that is that to acknowledge first that Strasbourg has acknowledged that positive obligations can exist at a higher or a more specific level. A more general or a more specific level is the first part of the stepping stone. The second point to acknowledge goes to a submission or an implication in a submission that my learned friend sought to make yesterday. She said, well, rights are engaged, so you need recognition of this type or form. So this isn't an implementation question, and so you don't get a broad margin or possibly consensus, and its importance to the establishment of a positive obligation is lessened. and we respectfully don't agree. The rights that are engaged and the fact that rights are engaged, as we accept, does not equal and does not lead automatically to the need for any particular form of recognition. It doesn't place particular obligations or any obligations on the state. What it does is to require that in a positive obligation case, the three-stage test or the four-stage test or the factorial test must be applied. It simply means that you then have to ask and answer the positive obligation questions. And so what engagement does in the structure of the analysis, whether you come at it negative or positive, what the engagement thing does is simply to tee up the questions. It doesn't provide the answer, which was the implication of my learned friend's submission. It's simply the necessary premise for the questions to be asked. And then you say, in relation to gay marriage or X on the passport or whatever else it is that you're considering, then you say, well, is there a positive obligation in relation to any or all of those? But so the elision that is very difficult, we respectfully submit, and was simply an elision really done by implication in the submissions you heard yesterday, is to jump from engagement to no justification for or positive obligation to. And our respectful submission is that that isn't the way it works. In order to get into Article 8, you have to demonstrate that you're dealing with private life. And once you're dealing with private life, you then have to ask and answer the question. Let's take it positive, because the positive-negative thing doesn't really matter for this purpose. Take the positive thing. You then just simply have to ask, is there a justification for imposing, or should this positive obligation be imposed? And that takes one straight back to Hannah Lynham. So it is the premise for the questions being asked, engagement, rather than an assistance in how you should answer them.
I thought you were actually going to make a separate point, which is different levels of margin of appreciation, by reference to the subject matter of what you're looking at. Because if you have permitted a person to undergo transgender surgery or to become transgender, then it heightens, it reduces the level of the margin when it comes to an absence of system for changing the birth certificate. So the birth certificate would catch up with what you've allowed.
Well, my lady, yes, but that issue, those sorts of questions, would in any event feed into and sit within the framework that Hannah Lynham identifies. I think the question my Lady Rose was asking is the prior question. What flows from engagement? But my lady is right. There may be all sorts of things that will play into those questions, which is why I'm working through the factors here.
Yes, but in your answer, you sort of jumped from justification to whether there's a positive obligation. But I think at the outset you said, well, these factors are both relevant to asking the question, is there a positive obligation to allow an X marker? And the flip side of that is there a justification for not allowing an X marker? Yes. But the factors that you're taking us through, I think, are equally, that's not really two different questions in this.
My lady, it isn't. I'm sorry. That's why I, halfway through the answer, said let's strip out the positive versus negative thing, because it confuses. You could equally well apply the factorial approach in Hannah Lynham to the question, is there justification if I were to analyse this as involving an interference by the state negatively? They would feed then directly into justification. And that's the chime back to SC, because SC was dealing with justification in the discrimination context, but it doesn't make any difference. If you analyse it as a positive obligation, you ask the same questions, but simply in the context of saying, is there an imposition to be done here? In any event, my learned friend has deliberately confined this challenge to X on the passport. I'll come back to the significance of that, but the reason for that isolation is not hard to find forensically, it avoids all of the issues associated with providing a particular form of recognition in one area, which I'll come back to. But what my learned friend cannot do, I respectfully submit, when considering positive obligation, is then to refuse to confront the logic and the ramifications of that argument with all of the issues that that will bring, including in relation to consensus. So once you recognise that this is a broader question, all of a sudden the consensus issue would apply to those broader issues as well, and you'd be asking all sorts of questions about those. So one can see the forensic, as I say, attraction of trying to confine it to X on the passport. But my submission will be, and it's coming, that there is a broader logic to be confronted. But the courts below, again, we respectfully submit, were right to approach this on the basis that what has to be established in relation to consensus particularly, given that choice of target, is that there is a current, a now obligation, a positive obligation on a state to have X on the passport. And still on consensus, there is consensus, or not, in relation to that particular form of recognition, as it were. So that's the principal bit in relation to consensus and the Council of Europe. International law I wanted to deal with briefly in relation to consensus. My learned friend makes a submission that consensus amongst Council of Europe member states is less important or relevant in this context than the emerging international trend, as she puts it. My respectful submission is that that is untenable. The Council of Europe position is the focus for all of the reasons that I gave earlier. There are no doubt circumstances in which it might be appropriate, as it were, not to ignore evidence of other international consensus. But in principle, that cannot be the driver for the reasons I was discussing with my Lady Arden. Or you have the absurdity of no C of E, but lots of international. That just doesn't make any sense. True it is that the court in Goodwin made reference to the international trends or the international context, but it is important, we respectfully submit, to place Goodwin in its proper context. And we've dealt with that aspect in our case, so I don't want to take up time going back to all of that. But my submission is not, as it were, necessarily to ignore the position internationally outside the Council of Europe, but that on any view it is very much subsidiary and certainly couldn't be used, as I put it, as the driver. And that we note, and it's a point that bears on the Goodwin case as well, that may be why when the Grand Chamber came to consider the principles with the care that it did in Hämäläinen, which is the most recent Grand Chamber authority in this area, the European Court of Human Rights does not refer to the international position outside the Council of Europe at all. It focused entirely on the Council of Europe position, see paragraphs 67 and 73 to 75.
I suppose the position might be different, Sir James, if it were arguable that there was a binding rule of customary international law. And at one point yesterday, I thought it was being suggested there was such a rule, but we were not referred to any in practice.
Well, you don't need me to tell you what you need to establish for the purpose of a customary rule of customary international law, which I assume underlay my Lord's invitation to my learned friend to address you on state practice as one of the critical components of that, along with opinio juris. My respectful submission is that the same discipline would have to be brought to bear. If such a submission were to be made in relation to CIL, it would have to be an obligation. If it was to drive the imposition of a positive obligation in Strasbourg, it would have to be an obligation to introduce X on the passport. So you need the same disciplined focus on the obligation that you're actually contending for. And then, if you were going to say customary international law, you'd have to go through the state practice that bore on that. And whether opinio juris did it. And of course, there's been no suggestion entirely correctly, by my learned friend Miss Carl's Frisk, that the Yoga Carta principles amount to opinio juris. As we know, opinio juris is a concept which shows states regarding themselves as being under a species of obligation as a result of the variety of things that feed into that. Just finally, still on the principle in relation to international law, the other attempts to draw succour from international law, and again I don't need to take up much time on this, but in principle the correct approach to the domestic courts in an ECHR context, having regard to international law, reports of committees, reports of experts and all of that, all the stuff that is normally referred to as soft law, has now been made very, very clear indeed from the two cases you dealt with and handed down on Friday. Can I just very briefly show you or give you the references to the paragraphs? I suspect this isn't going to be central, so perhaps I can just give you the references. In SC, the relevant paragraphs are 74 to 96, especially 76 to 79. And in AB, which was really, this was one of the central issues in AB, the relevant paragraphs are 61 and 62 are probably the key ones. But note in particular how that is carried through in relation to general comments at paragraphs 64 to 67. And the essential themes coming out of that are, true it is that Strasbourg regularly refers to a whole variety of international instruments, but it is never the position that Strasbourg says we are here to determine whether or not a state breached the international obligations, most frequently arising under the UNCRC. Theme 1. Theme 2 is when you are dealing with an attempt to rely on international law or commentary for the purpose of, for the legitimate purpose of aiding interpretation as to the meaning and scope of convention rights under the Demir principle, you need to be jolly careful about the nature of the thing that you are dealing with. And you need to be jolly careful about that because very regularly in the past, extensive reference has been made to things like general comments, and you need to bear in mind all the notes of caution which Lord Bingham all those years ago in Jones and Saudi Arabia laid down for the first time, namely they are not adjudicative bodies, they're there performing a different function even under the international scheme in which they live, and so one needs to be extraordinarily careful before simply just throwing in any instrument that one comes across, including, for example, the same logic and principles would apply, for example, to reliance, which is relatively frequently done, I think has certainly been done in writing in this case, on Parliamentary Assembly resolutions. They're absolutely within that territory of the real note of caution laid down in the AB case in particular, because of the nature of the body. It's there to recommend, it's there to suggest to states that they might like to move their laws in a particular direction. And that, of course, isn't evidence of state practice. It's just evidence that a body charged with that particular function suggests that might be a good idea. And that's a very, very different thing in terms of influencing the imposition of an obligation of the kind which is asserted here. So that's the approach in principle. So far as the application of those principles are concerned, I can be very brief. The evidence of consensus is dealt with in particular in our case at paragraph 48 and following, by reference in particular to Ms. O'Neill's first statement, paragraphs 37 to 55 at page 434 in the bundle. So far as the Council of Europe is concerned, see our case at paragraphs 52 to 54, electronic 218 to 219. There is no consensus amongst contracting states about either legal recognition of non-binary people generally or specifically X on the passport. At the time of the Court of Appeal judgment, only 2 states permitted X marker on passports, Denmark and Malta. There is 1 more now, Iceland, and only Iceland recognises non-binary status in the law more generally. There have been some cases, some of which are still being appealed, in some other states within the Council of Europe, Belgium, Germany, Netherlands, Austria and so on, but it's far from clear whether those cases have led to finality or to legislative change, which would be what would be required for the position to change and to be a factor in consensus at all. So when my learned friend says, as she did yesterday in relation to Council of Europe consensus, I accept, she says, that I can't point to more than 50% of Council of Europe states as a consensus supporting the imposition of the positive obligation she invites you to impose. She is modest. The number is 3. As far as international is concerned, again, there can be a debate, principally with Ms. Cars-Frisk on this, but there can be a debate about the precise number and whether you take into account, for example, intersex or you don't, but the numbers at the max are 12 or 13, and on our view of the case, see our case at paragraph 55, if you actually bring it down to non-binary, the consensus in inverted commas on X markers in the passports is very thin indeed. Australia, Canada, India, Nepal, New Zealand and Pakistan. And the United States, far from being, we respectfully submit, an example which supports my learned friends, creates difficulties, because what it does is to illustrate that different states are taking different positions at different points in time. And they haven't yet legislated. More generally, in relation to international law, so that's a position on consensus, the Yogyakarta principles, it might be thought, are an exemplar, a paradigm example of the difficulties that led to the recent helpful clarification of the true limits in principle of reliance on international law in A, B and SC. The Yogyakarta principles have never been relied on by the European Court, save for in the dissenting judgment in Hämäläinen. My learned friend Miss Cars-Frisk attempted to introduce them by using the word consensus, but it's quite important to note that she properly put after the word consensus of experts. And that, we respectfully submit, is not the consensus we are after. If you're going to establish any form of consensus or trend, it has to be a consensus or trend of states. So my learned friend Ms. Cars-Frisk's answer to that was to say, well, what they were doing was merely to restate, in accordance with the terms of the preface that she took you to, international law. And in that way you could be satisfied that there was a sound basis in international law for all the various principles they then set out. And with the greatest respect to her and to the authors of the Yogyakarta principles, whose eminence is not in doubt, that is untenable. There is absolutely no indication in the face of that report as to how it was thought they properly reflected principles currently established and existing under international law. If they had set out that analysis and reasoning, or set out or explained the basis on which they so concluded, they would have bumped into a very large rock indeed very soon in that exercise, because, as was pointed out in questions yesterday, that assertion was fundamentally undermined, or would be fundamentally undermined, by the entire absence of any consideration of state practice. And finally, bearing in mind the discipline imposed by A, B and SC, they are not, in any sense of the word, an adjudicative body, performing the sort of function which is the precondition to reliance applying A, B and SC. So our submission in relation to consensus is that the Court of Appeal's reasoning and judgment, with this at the heart of their reasoning at paragraphs 74 to 84 of their judgment, are not merely, if I'm allowed to double the negatives, not wrong, they are self-evidently correct. And likewise, in relation to the approach and analysis of the judge in this respect at first instance, see his judgment at paragraphs 127 to 129. So the third of the factors, which I called in shorthand public interest when I was introducing the factors, perhaps needs a little more exposition. It's the balance to be struck effectively between private rights and impacts, which I'll come to as a discrete topic as my fourth topic, and other public interests. So the focus here in relation to this third factor is on the state and its systems. That's the focus of this. And again, if I may, I can break this down into principle first and then application second. So far as principle is concerned, the question at this stage is whether the state is entitled to take the view that if a change is to be made, it should be made coherently and either across the board or at least with across the board having been carefully and properly thought through. No doubt any party to litigation can present their challenge in whatever way forensically suits them. But as I submitted earlier, if they do that, the state is entitled to say in response, we need to consider the consequences and the ramifications of the logic. And this, X in the passport, is plainly not an isolated issue. And the consequence of that is that the state can take the time necessary for that consideration. It can take the view that broader issues and impacts are and should be considered with care with all of the issues that they raise. And they can decide, we submit, within the convention scheme, that it isn't appropriate to introduce a sole measure challenged in isolation. My learned friend Ms Gallifant yesterday took the extreme position that coherence was not capable of being a legitimate aim. We respectfully submit that the judge at first instance at paragraph 119 and the Court of Appeal in their analysis at paragraphs 62 to 70 and 105, especially perhaps 105, rightly held that the need for coherence of any change across government and in law was of obvious importance. One can see the recognition of these broader schematic interests being taken into account in the final sentence of paragraph 67 of Hämäläinen, the public interests, to use their phrase, being balanced and needing to be balanced. They also dealt with the coherence of the administrative and legal practices within the domestic legal system at paragraph 66. But standing back from authority and looking at it as a point of principle, our submission is that the state is entitled to and should consider any change and its appropriateness, having regard to the scheme of administration and law as a whole, not just passport in isolation. The coherence of the system for recognition of gender is a legitimate aim. So, for example, a proper need to consider whether legislation will be required to at least deal with some of the myriad ways in which English law is currently premised on the MF distinction. That raises questions, of course, about which body is appropriate even under our separation of powers to make those sorts of changes. And you can't just escape that from saying, well, I've selected a target that you could change by reference to the royal prerogatives. You don't need to bother with any of that. And the scale of the change is against the appellant in this case, we respectfully submit. It isn't just a thing that could be done with relatively greater ease and cost, because there's a highly significant set of linked social and administrative changes that come with it. And it's obvious why that should be so. There are real and proper sensitivities about change in one corner with policy and legal implications across the scheme of government. Not the least of which is that if you move, if one looks at it purely from a legal point of view and a challenge point of view, if you move in one area, we know entirely what happens next. You create the comparator target. And so you need, in policy terms, to think through whether the changes and the logic of the changes leads to an acceptable position or a position that requires a change in another area, not least from that perspective. And if there's a variety of ways in which you could deal with the issues, you're, as it were, layering on all of the other features that I identified earlier, including consensus in relation to those other areas, including whether those other areas raise complex social issues. Those all start coming into play if, or unless I should say, the thing can be tightly confined to X on the passports, as my learned friend seeks for forensic reasons to do. I wanted to refer you to one domestic authority, very well known in this context, which is the Bellinger case. And the paragraphs I want, I think, start at 1106. Case itself starts at 1095, at 1106. The paragraphs I really want are all in the speech of Lord Nichols. And can I refer you in particular to para 32 first? Raising the breadth of issues point, teeing it up, as it were, in para 32, and then 39, really through. Can I invite you to read 2 or 3 pages if that isn't too burdensome? But it's paras 39 through to the end of para 45, so 39 to the end of para 45, in particular para 45. We say the analogy is clear, the reasoning is compelling, and the principle is encapsulated at paragraph 45. My learned friend's submission of principle in answer to all of this is to say, well, no, if you go back to the Strasbourg case law, all of the cases are confined to the coherence or logistics of the measure in question and not the broader question of coherence. And my short answer to that is that they are simply examples. Those cases simply provide examples of coherence at play. they're not a good reason, and they don't exclude broader issues of coherence. Indeed, they positively support it. Joined-up policy is a virtue and not a vice. And that falls perfectly contentedly within the language that was used in Hämäläinen at paragraph 66, the burden on the state and so on. That plainly opens up a broader consideration, or consideration of the broader issues that are related to, including likely consequential issues on the logic of a particular specific contemplated change.
So is that how you get this within Article 8.2, as Ms. Gallifent said that you have to? You say that when you're looking at what the burden is on the state, you have to... Do we assess what we think the state would have to do, or does the state assess? Is it on the state say so that they want to look at this more broadly, or is that something we have to accept as a reasonable stance to take? Before it becomes part of the burden.
Yes. My submission ultimately would be that you need to, first of all, assess, which probably would be for the court, whether in truth these other consequences arise. The state can't just turn up and say, well, here are some completely anomalous and strange things that might happen when that bears no relation to reality. But if the position is that the court is satisfied that on the logic of the position which is taken by a particular claimant, other things would need to be thought about per Bellinger, at that stage you've got a constitutional actor question. And at that stage we respectfully submit it's ultimately going to be a question of whether the court is well placed to make those judgments, or whether they're judgments appropriately to be made by the other constitutional actors in play. And of course that may differ, because some of this may be government, if it's royal prerogative, and some of this may be parliamentary or legislative.
I mentioned the role of the Strasbourg court in its supervisory jurisdiction.
Yes.
And it may be that the analogy starts to fall down at this point, because Strasbourg would determine the issue which you've just mentioned and wouldn't go on to the constitutional question.
No. Well, my lady, that is true, but that then leads back, as it were, to one of the submissions I was making about the G case, which is on one analysis of it, the separation of powers, the constitutional actor question, is an additional question to be asked by the courts, arising in a domestic context. But there are some features of margin which plainly are common, as it were, whether you call them margin under Strasbourg or whether you call them domestic respect, the nature of the issue, the consensus that will be taken into account, and so on. And then there are additional questions of the kind we're now discussing.
Indeed, which may not fall to be asked in a civil law country where civil rights and constitutional rights will override the general law. It's not, they don't have parliamentary sovereignty as we understand it.
My lady, perhaps not, but the Strasbourg court would be respectful of that, and that is a relevant thing to analyse, not least because of the Human Rights Act.
So where do you say this fits in Article 8.2?
My lady, we say this is part of the balancing that needs to be done. If and to the extent, if you analyse it negatively and you say there's an interference, then we say that having a coherent regime and consideration of the broader set of recognition or types of recognition or form of recognition question falls plainly within 8.2 as something a state would be entitled to consider and to balance. If one analyses it positively, as a positive obligation thing, you've got paragraph 67 of Hämäläinen permitting you to do exactly the same thing through its references to balancing, quote, public interests, and its references in paragraph 66 to burdens on the state.
I think part of the challenge was that you can't, so it said, find a peg within Article 8.2, a list of the legitimate aims which may be pursued. And we're told in Hämäläinen that they may be relevant to assessment of the positive obligation. And I wonder what you had to say about that. Just for reference, page 741, you get the text of Article 8.2 in Hämäläinen itself.
Well, my Lord, rights and interests of others immediately springs to mind in having a coherent system of law.
But if you're talking about, I mean, obviously legitimate aim is an aspect of a justification of an interference. And if you're analysing it in terms of a positive obligation, then legitimate aim as such, I don't think would arise. It would rather be a factor. In this issue, would rather be a factor bearing on the question whether there was indeed a positive obligation.
My Lord, I think that may be right, and it's also probably why they say as they do.
Well, the reason I asked the question in the way that I did was paragraph 65 of Hämäläinen.
Yes, that's where I was about to go.
Page 747.
May have a certain relevance.
Yes. So,
but only a certain relevance, which feeds into my Lord Rees' question.
Yes. Well, I'm inviting your submissions on how you deal with paragraph 65 and the text of Article 8.2.
My submission is that one needs to be a bit careful about direct transposition of all of the concepts that would normally fit in 8.2 if one was analysing it negatively, for inter alia the reasons my Lord Rees has just pointed out. That, no doubt, I submit, is why in para 65 they don't say you apply exactly the same schematic analysis, and they say the aims in the second paragraph being of a certain relevance. But if you were to analyse it anyway, to come back to my Lord's question directly, the idea that you couldn't get public interests within 8.2, I respectfully submit, is a very difficult thing, whether one puts it into rights of others as being having an interest in a coherent scheme of law, or one analyses it by saying, actually, what the Strasbourg Court have done in the context of Hämäläinen is to say our preferred route of analysis is positive. Look at paragraph 64. Here, then, are the factors that you take into account in analysing that. They include, see the fourth last line in paragraph 67, public interests.
They specifically mention coherence.
And they specifically mention coherence. So my respectful submission is that they plainly can't have taken the view that even though you could look at Article 8.2 and pretend it was a negative interference and so on, they plainly don't take the view that that additional strand of analysis, even if applicable, would preclude public interest and coherence being relevant. Because otherwise there'd be a discordance.
And fair balance is another way of expressing concepts of proportionality.
It is.
So that it may not be as different as it might look.
Yes. But we're here dealing with a very narrow question, which is, can you escape from even going to coherence and public interests by saying, well, actually, look at Article 8.2, pretend it's a negative analysis, and then say you've got difficulty cramming public interest into 8.2.
Yeah, because you've dealt with that at 65, haven't you, by saying it's a fair balance. It has to be between the community and the individual.
My lady, yes. But I think the real punchline, perhaps, is look at 67.
The specific reference.
Yeah.
Just
Sorry,
going on to back to Article 8.2.
Yes.
Of course, the Chamber had treated it as an interference case. I was just looking at paragraph 36 in Hämäläinen, page 741. I mean, just to note that when the Chamber thought that it had to analyse it as a negative interference case,
health and morals as well as rights
in accordance with the law. Yeah.
Yeah.
Thank you.
I was 50% right anyway. Health and morals, perhaps, yeah, as well. But I don't think either of us is suggesting, well, maybe we are, if my own friend's making that submission, but my positive submission is that it shouldn't make a great deal of difference at this stage of the analysis, whether you analyse it as positive or negative. The really important thing is what are the relevant factors that feed in. That's the short point.
The positive obligation is not an absolute one by any means.
It's a fair balance, as you pointed out.
When you mentioned earlier that there are umpteen Strasbourg judgments concerned, for example, with the equalisation of pension rights between the sexes.
Yes.
Or retirement ages, or so on and so forth. And in them, and indeed other sorts of cases where the court has been looking at a potential change which had widespread ramifications. Obviously, treating men and women equally in relation to pension rights and retirement is an issue with colossal ramifications. And you took us to references in SC to numerous judgments where the court has accepted that an admittedly discriminatory situation can be allowed to persist for a time while steps are taken to reform the situation, realizing you can't do everything at once. I don't think if you look at those cases you find that analysed in terms of a legitimate aim. Yeah. I checked Schalk, slightly different, same sex, but there it's not referred to in those terms at all. It's rather like in Hämäläinen.
It's just treated as a factorial analysis with the various things that we know and love floating.
Yes, yeah. I mean, so for example, in Steck, itself, which is about equalisation of pension rights. Yeah. The court reiterates all the formulas about how discriminatory treatment has to be justified as pursuing legitimate aim by proportionate means. But when it comes to the bit, it doesn't. I don't think it actually addresses the practical problems arising in trying to remedy such long-standing and deep-seated arrangements in terms of an identifiable Article 8.2 or 9.10.2, 11.2 legitimate aim.
And that was, if I'm on my Lord's point, that to some extent chimes with the point I made at the very beginning, which is that now we have as it were, the clarity of the analysis that fed into SC. It's actually jolly interesting going back to quite a range of cases to see how that fits. And actually, I think Hämäläinen was not one of the cases that was considered in SC, but if you look at the reason... It
was considered thoroughly in the course of considering what to say in the judgment.
Yes, but not directly, but we can see it now in the context of positive obligation, something rather different, and in a wholly different context, as it were, and all of a sudden the analysis looks like it's the same. Yeah. But they're always doing that relative weighing exercise, identifying the factors that play into the particular issue that they're considering, rather than necessarily treating the basic structure as a straitjacket, rather than simply as the house within which you then start to analyse. So, my lords, my ladies, that is what we say about the principled approach to the balance to be struck and coherence and all of that. Come to the application of it and some of my learned friends' submissions in relation to that, if I may.
It occurs to me,
yes,
sorry to interrupt, but it just occurs to me that another illustration of it is a line of cases, including Marx and Belgium and Wouden and Liechtenstein.
Where they do prospective remedy.
Exactly. And they're not doing that because of any legitimate aim identified in the text of the convention, but it's to protect legal certainty, essentially. Yes. And what the French would, what we might call the rule of law, or the French would call ordre public, just having an orderly transition. Yeah.
But that does chime very directly, albeit in a slightly different context, with the theme, a large chunk of that first part of the analysis leading up to 115 in SC, and the emphasis on the transitional nature. And again, feeds back, you can call the same beast by many names. I mean, it's evolving rights, it's the transition of society from one place to another, however deep-seated the previous position. It's avoiding the uncertainties that would flow if you move too quickly.
Yes, and indeed, you can see, whereas Steck dealt with the issue by allowing time, effectively. The European Court of Justice dealt with the same issue about equalising pension rights by imposing a prospective-only remedy in Barber.
Yeah.
That marks as the case I had in mind when I raised this point yesterday afternoon.
Yeah. Yeah. Well, prospective remedies is a interesting and current topic.
Yes.
If 8 o'clock last night was anything to go by. So far as application is concerned, a number of different heads under application, if I may. First of all, coherence itself. The practicalities in relation to coherence are dealt with in Ms O'Neill's first statement in a long section between paragraphs 56 and 89, starting at 437, and are summarised, I hope, slightly more crisply in our case at paragraph 31. But Ms O'Neill's statement is at least worth a quick flick, because what it does is to consider across government departments the sort of things that would follow. Where does the logic of this change, if it were to be made, lead in each sphere of government, or in some of the spheres of government? And it indicates very, very graphically the complex and difficult and intertwined set of issues and changes that would need to be considered. And that points up the complexity and the nature of those particular issues. It also, with respect, highlights a point that my Lord the President made yesterday to my learned friend, which is, sorry to keep bashing my learned friend about the oddity of the case that's being advanced, but it's another ground for pausing a bit in relation to the nature of this challenge, because, as my Lord pointed out yesterday, the forensic choices that have been made lead to the assertion that X on the passport is the subject of a positive obligation, but the arguably more serious impacts that might occur in relation to the individual are left unchallenged. I mean, one can think of any number of examples. Pension rights we were talking about a minute ago. That would be one. Perhaps more personally, more graphically, more intrusively, all sorts of questions about the prison system were someone to be sentenced. But there are lots of different ramifications.
But that's all she does, really, doesn't she? Her evidence doesn't really go much further than saying, goodness, look at all the areas of our law where there's a traditional division between male and female. Is there anywhere in her statement where she says, and we have thought carefully about which of these we would have to address if this X marker in the passport was going to be allowed?
Well, my lady,
has the debate over all these years got much further than still saying this will all be terribly complicated and the potential ramifications are very great? I mean, has anyone addressed what are actually the potential ramifications?
My lady, yes. I mean, it's a fair point, but my answer to that is that the starting point has got to be to identify the potential logic and the flow out, and that isn't a thing to be dismissed, because what it throws up is that if you're going to do a recognition thing, then that may well involve departments that are not, and institutions that are not purely government. Legislative change may be needed, for example. And so that's the first point to note. The second point to note is that it does throw up the difficulty of just turning up and saying, I'm going to confine my claim for forensic reasons to this particular sphere, when if you look at those other areas where the logic leads, there is a very clear nature to those issues, namely difficult and complex social issues about precisely how far you can go, you should go, Parliament can go, or Parliament should go. So it illustrates the nature. And at various points in the argument, when my learned friend has confronted difficulty on some of the factors that Hannah Linen lays down, her run-to place is to say, well, don't worry about all this. I'm going to come to this very directly in a second. But her run-to place is to say, well, I don't have to worry about that because there isn't any necessary flow through.
But it's a bit of a leap from X markers in the passport to a reconfiguration of the prison system, which is...
Well, I'm not allowed to question my lady, but I'm not. My immediate reaction is
You can put
why?
a rhetorical question.
Yes, but why is the answer to that? I mean, there is logic to it. You are, at the moment, there is no specific and express recognition in domestic law of this status. So that's your prior and first question. And once you open the door to some part of it through the exercise of royal prerogative, we know what will come. The comparators are there. And so it's appropriate and necessary, we submit, to think through the ramifications. It isn't such a leap, and it certainly isn't such a leap to say, in relation to pension rights, for example, one would have to grapple with how all those worked. This is it's a major change that is being proposed. That's no doubt why the consensus in Europe is as it is, because these are extremely difficult issues. The size of the scale of the issues is important, I respectfully submit, and underpins, no doubt, the lack of consensus. I wanted to pick up 2 points, and they may go a bit more to my lady's question. I wanted to pick up 2 points that my learned friend made by way of submission and to try and seek to give you an answer to them. She says first, as I understand it, that the analysis implies that you can't have a coherence justification, effectively, unless it is shown that doing the thing the subject of the positive obligation, here X on the passport, would inevitably and necessarily lead to the consequential change. And we do submit that that isn't a good submission. It's a straw man. Of course, one could, as a matter of law, exercise the royal prerogative. You don't need legislation. And as a matter of law, doing that wouldn't have immediate and necessary consequential effects. But what that change would do is to lead to a recognition in one corner with all the question that throws in relation to other issues. You will be moving from MF as a binary structure in the law to something fundamentally different. So it isn't a prerequisite to being able to rely upon the coherence of the system to say it's a necessary consequence of the change. And of course, I say, formally, royal prerogative is royal prerogative. You don't need legislation at all, unless, on occasion, this court tells us we need legislation. But under the ECHR system and the principles we've been going through, my respectful submission is that that isn't a necessary precursor or precondition to reliance on this set of considerations. My learned friend also suggests, secondly, that there is no necessary recognition of third gender. X as neutral on the passports. So you could change with impunity, without wider ramifications. So there's no force, she says, to the need for coherent consideration and change. Well, I've dealt with that in large part already in the submissions, but just to pull the points together, my submission ultimately is that that's an unrealistic and selective submission. First, the entire driver for the change in the context of passports is said to be the importance of third gender. There's no policy driver or reason to change it otherwise, so this is genuinely a having it both ways submission. The claim is premised on the driver for change being the need for non-binary people to have a status that reflects their identity. And indeed we note that in this respect the appellant advocates the use of a passport for reasons other than travel, which I'll come back to. It's an important point that she was making about the impact. But secondly, the criteria would inevitably include and need to include the acceptable bases for ticking X, and would thus need to identify non-binary, intersex or whatever. You then got immediately the broader question that I referred to earlier, which is it a good idea in principle to have something which is pure choice? And if it isn't, because the engine isn't decoupled from the boat, then you've got to start working out which are the criteria that would need to be applied.
Strasbourg allows you to do that, doesn't it?
Strasbourg does,
yeah.
I submit. The third point is that one cannot have the position both ways. My learned friend positively advocates, as I say, the use and seriousness and regularity of the use of the passport for identification purposes, but that precisely raises the broader issues. What is to be made of it in this way? Is this a change of status in all but name? What ramifications from that change? And of course, finally, there will be a target created for the next challenge if it was indeed premised on the basis that the criteria included the need for someone to be non-binary, if it included other things like intersex. The point was made under coherence that there was an incoherence because most trans people do not have the certificates that are set up under the Gender Recognition Act, but the system nevertheless has allowed them and continues to allow them to change passport, change details in the passport from M to F or F to M, and so already tolerates that degree of administrative incoherence. Those are, of course, changes within the MF system, simply another way of achieving that which the law permits anyway. But in the more principled answer, it might be thought, that's a practical answer, but the more principled answer is that if anything, and if there is incoherence, that reinforces the need to consider matters across the breadth of the spectrum, all the more so if the passport is accepted as being a document reflecting status and in broad use for identity purposes and other purposes. That was effectively the point that the Court of Appeal made in answer to this, reinforcing the need for the breadth of vision at paragraphs 68 to 69. Then my learned friend says there's another incoherence, which is that the appellant had surgery in the NHS, and so there is an analogue, an incoherence analogue with the Goodwin case. My submission is that that reads too much into the Goodwin case. All of these cases are about factors that balance, and the balance in Goodwin, given the state of societal development, was plainly very, very different. But of course, the principled answer is that the NHS's position is focused on justified medical intervention and not law. The welcome fact that the NHS were prepared to do this, as they evidently were, is illustrative of the fact that the system as a whole is not set up, as it were, against non-binary people. But that isn't the issue that we're confronting. That isn't the question that we're confronting. The question that we're confronting is whether or not there's a positive obligation now to have the very specific form of X on the passport. And the argument cannot be, in principle we submit, that if you accord one form of respect, if one analyses in those terms, it necessarily follows that the wedge has been put in and that all other things must follow.
Indeed, that would be a disincentive for gradual
any change or any respect
in a positive direction.
My lord, quite so. So that's what we say about coherence, with those two specific aspects of incoherence that were identified by my learned friend. Security and identity next as an aspect of incoherence. I don't want to take long on this. My Lady Arden raised it earlier. We've dealt with it in our case at paragraphs 44 to 47, and just by way of very brief summary, there were two ways in which the Secretary of State relied on the security justification. Firstly, that it's relevant to preventing fraud when issuing a passport, and secondly, relevance to identification of travellers at borders. On the first of those, the point is that when a passport is issued in a different gender, it provides an opportunity to commit fraud. And that position was evidenced in, just to give you a succession, if I may, two or three references. Woodhouse at paragraph 28, the internal review at section 3, and C and the Secretary of State for Work and Pensions, a Supreme Court case, at paragraph 33, which is in, give me 1 second, it starts on page 1207, and paragraph 33 is at 1219, where Lady Hale said the second legitimate aim put forward is to identify and detect fraud. There is a particular risk of identity theft in the case of transgender customers. Fraudster may obtain a birth certificate in the customer's original name and use this along with other evidence to obtain a national insurance number allocated to that name, and so on. And that risk, we submit, is enhanced in relation to X markers, as there is a risk that fraudsters may obtain a passport in the birth gender of a person with an X marker, same point as for the trans community, and that fraudsters may apply for a passport with an X marker, and then the passport office can't cross-check the gender identity with the MF, and so on. So there are potential issues there. And on the second of the aspects of security, the identification of travellers at the borders, again, there was evidence that sex was a factor used to conduct identity checks at borders, and the evidence, again, was considered by the courts below. The ICAO survey was criticised by my learned friend as being concerned only with the question of removing sex markers altogether, but the issues we submit are not as discrete as are being made out. Having the X marker means that the MF data field is not, in practical terms, operative, so there are difficulties of the kind that my lady was referring to. In essence, therefore, the position is that, so far as this court is concerned, those sorts of points were accepted as relevant by the judge at first instance. Paragraph 118, his judgment at page 329, but were rejected as relevant by the Court of Appeal at paragraphs 72 to 73, page 274. But the basis of rejection was narrow. It was on the basis that other countries permit X. Other countries within the ICAO arrangements permit X on the passport without any issue. We've dealt with that ground of rejection in our case at paragraph 47, page 215, and the short point is this. The fact that other countries permit X on the passport simply means that they've decided to take those risks or to make other alterations to seek to mitigate the concerns, or they've made different systemic judgments. Our submission is that there's no necessary undermining of the view formed in this country about that angle, the security angle, by virtue of the fact that other countries have either chosen to take the risk on or have made different arrangements or whatever. So that's the very short point, the appellate point, as it were, in relation to this. So our submission is that security in both of those aspects is a relevant feature. The third aspect of public interest, as it were, is that there is ongoing consideration of these issues. I think my Lady Rose's description of it as stuttering is a fair description. But those issues and their consideration were considered with care by the judge, especially at paragraphs, the first instance judge that is, especially at 122 to 126 of his judgment, with the punchline at paragraph 130. We've set out the chronology in the case at paragraph 41. We are not doing nothing, as my learned friend put it. In any event, she must establish that there is a current obligation to put X on the passports, and my submission is there's no positive obligation to do so for all the reasons given. But the fact that these complex issues are under consideration is at least a relevant factor we respectfully submit, and a positive feature. We're not simply ignoring the issues. One can argue, no doubt, about the pace of change. One can argue about how far we've got down the road, or Parliament has got down the road, but there is ongoing work, as is clear from all of the evidence. And in essence, the point that we make is that it is really a responsive one in relation to it. This is partly positive, which is it can only be a good thing that the issues are being thought about seriously, but partly a responsive point. And the responsive point is that any attempt to compare the position that we are currently in with the position as it was in Goodwin, and paragraph 92 of Goodwin, with the inaction over the prolonged period of 16 years, as it were, that the European Court found telling in Goodwin in the context of transsexuals, it is inapt.
Can I ask you, Sir James, on the issue of security, it's dealt with by the Court of Appeal in paragraph 73 on page 274. Seems rather reminiscent of the Begum case. At paragraph 72, Lady Justice King tells us that the Secretary of State relies on matters which go to issues of security in relation to combating identity fraud and theft and the need for security at borders. In my judgment, issues of security don't affect the fair balance in circumstances where the ICAO has for many years been content for passports to carry an X marker. I'm just wondering what the basis is for dismissing the Secretary of State's concerns on the basis that the ICAO is content for passports to have an X marker.
My Lord, I think if one puts it in, I was trying not to mention Begum, but Begum is there, without being unduly unkind to the Court of Appeal, I think the thinking is, or was, we can effectively dismiss this as having no rational basis because other countries do it differently. And the submission that I made earlier goes directly to that. Once you work out that actually the fact that other countries do it differently does not answer the security concern, it simply means they've decided to take a greater risk or struck the balance in a different place, then there is plainly an evidential and an evidenced base for this, and it cannot be dismissed as irrational. And I'm not sure if that point goes, the Court of Appeal would have dismissed it as irrational. And at that point, you certainly would get into who is the right person to make this judgment, which is the Begum issue.
Yes, yes. I'm particularly struck by the priority given to the assessment of a body that's produced a report on machine-readable passports over that of the Secretary of State.
Yeah. Well, my Lord, you have our submission on it. We respectfully submit it's relevant and there is a proper and rational basis for it, and that the basis for rejecting that, and indeed for rejecting the learned judge's acceptance of those points, was not a proper one, with the greatest respect to the Court of Appeal. Finally, I wanted to give you references in relation to, sorry, as the final point on coherence, to refer simply to cost and the number of people likely to benefit. And again, I don't want to make much of this. It's always a a difficult and sensitive area, how much those sorts of things can play into the analysis, but even to the extent that they're relevant, and we respectfully submit that they are at least factors, we've dealt with them in our case at paragraphs 62 to 63. And the short and essential point is that some significant cost, and obviously the further out you go in terms of what you have to change, the greater the cost, and number of people benefiting is very small. But I entirely recognise, in relation particularly to the latter point, the strength of the analysis, not least from SC, that says protecting small minorities is a jolly good thing. So, subject to that, I take that point lightly. Can I then focus as the... keep turning to the clock, but the clock has now become 10 minutes slow, as far as one can tell. Can I focus on the individual impact and the focus on the individual as the fourth of the factors that the Strasbourg Court and its analysis in Hammerlein gives rise to? And again, I break it down into principles first of all, and then application second. So far as the principles are concerned, the first submission that we make is that whether fundamental values or essential aspects of private life are an issue in relation to the particular step, it is said is the positive obligation, is the focus and should be the focus. So it isn't just generally whether issues of sensitive private life such as gender are involved, it's the question much more focused as to whether or not the particular step engages those values, and if so, how. And that chimes with this being a positive step as an essential precondition to respect, in effect, the way it's put in Hammerlein and at paragraph 66. And it is key to recognise, I submit, that this is a relative question. This is a question which requires you to identify the particular step in question and then to analyse the extent of the prejudice that is suffered. And support for that proposition comes particularly from the Sojourner case, STJERNA, at paragraph 42, page 2279. So that's the first submission. The second submission is that it's important to bear in mind that the relative question I've just identified as the correct one is a factor. It does not determine, because you are in gender identity territory, it does not determine that there is a narrow margin. And that is made very, very clear, we submit, by the recent analysis of the Supreme Court in SC. And I particularly emphasise that because it does lead to the need for particular caution in the light of SC and the sophistication of the analysis with the different weighting factors playing in different ways potentially. It does play in directly to and causes a question mark to be put over, in particular the Lord Kerr's analysis in Steinfeld on this question. And I say with respect, I think my lady is also in the Court of Appeal in that case. Yes, whether one can go simply to say, well, there you are, you've got that involved, so it must be narrow. That now, I respectfully submit, has to be read in the light of the analysis of the Supreme Court in SC. It's also evident, it might be thought, in the context that we are dealing with, that the SC approach is perhaps rather reinforced by the thought that in this sort of context of gender identity and the difficult and complex societal issues related to them, it's worth bearing in mind that they are in effect the premise for the debate. Because you then have to address all of the other things that the Strasbourg Court has directed you to. But it is clear from all of the cases that the approach in Strasbourg is not to say gender identity, equivalent of a suspect ground, therefore narrow margin. They just don't do that. And you see that in particular in our very specific context from Hammerlein. Can I just invite you very briefly to go back to Hammerlein and I want for this purpose, again, paragraph 67. That's on page 748. And you will see that in 748, they identify the importance of the facet of an individual's existence or identity being at stake. Margin allowed to the state will be restricted. And then this, immediately in the next sentence, where, however, there is no consensus within member states of the Council of Europe, either as to the relative importance of the interest at stake or the best means of protecting it, particularly where the case raises sensitive moral or ethical issues, the margin will be wider. So you've got it doesn't trump, it doesn't lead automatically. That is entirely clear from 67. See also paragraph 75 over on page 749 at the bottom. In the absence of a European consensus and taking into account that the case at stake undoubtedly raises sensitive moral or ethical issues, the Court considers that the margin of appreciation to be afforded to the respondent state must still be a wide one. So that's how that principle gets translated. So they acknowledge the narrowing effect, as it were, of the suspect ground, if one wants to use that as the shorthand, or the nature of the individual interest at stake, but they nevertheless go on, exactly as you did in SC, to say, but nevertheless there may be certain factors pushing the other way, and if you've got an absence of consensus, the margin must still be wide. So that's how they analyse it in Hammerleinen. If you then go for something remarkably similar, into the Appellant, Gasson and Nicot and France case, and you go for this purpose to 139 to 140, which is on page 687. You see it expressed even more clearly, if possible. Look at 139 to start off with, and you'll note that there was a particular consensus position in Council of Europe states, leading, as it were, to the broad margin, but there were also, obviously, serious gender identity issues at stake and things that flowed from that. And then look at 140. The Court concludes from this that even though, that is, this being the consensus position, even though an important aspect of the identity of transgender persons is at stake in the context of their gender identity, the contracting parties retain wide discretion in dealing with whether or not to lay down such a requirement. And that is unsurprising, we respectfully submit, as an approach, particularly in the context of the imposition of a positive obligation, because, as I pointed out at the very outset, the imposition of such an obligation, if it is to be imposed here, as it were, would be, or would at least imply that it should be imposed, certainly if it was Strasbourg doing the analysis, across all members of the Council of Europe. It would become an integral obligation built into Article 8, if you will, that all states would have to conform to. They would all have to do it. And that, in a sensitive moral social context, is antithetical to the cautious, the very cautious approach that Strasbourg has exhibited throughout. And this way of looking at it, this approach, is entirely consistent, we submit, with the approach taken by the Court of Appeal in the McConnell case. Can I just invite you to electronically take that up? 1372. Is the start of it, and this was, as one sees from the head note, this was in the context of a trans man who gave at birth to a child and whether he should be registered as the father/parent as he wanted, or the mother, as per the Registrar General's case. That was the nature of the debate. And the court was, of course, in a sensitive ethical, moral area because the case raised difficult issues of gender identity. You will see that the Court of Appeal, Lord Burnett, Lady Justice King and Lord Justice Singh, noted that there was no consensus amongst Council of Europe states. See paragraphs 79 through to 82. Can I just invite you to read to yourselves those paragraphs? It's about a page, but we respectfully submit it resonates with many of the submissions that I've been making this morning and many of the thoughts and themes that one sees from the SC decision. The final point I wanted to make in relation to principle is that there is nothing we submit in AP in France, YY in Turkey, or Y in Romania, which have been referred to by the appellant, that touches Hämäläinen or the analysis of the Supreme Court in SC. There's nothing in those cases to suggest that there is in some way a trumping of the wide margin that is to be afforded in circumstances where societies have not developed to the point of requisite consensus within the Council of Europe. And that is a feature which, on the contrary, has been treated by the Strasbourg Court as leading to a wide margin, even in circumstances in which issues of gender identity of great sensitivity are raised. So far as the application of this fourth aspect about individual rights is concerned, it's a relative question, as I've indicated. But the first point we make is that we are dealing here with evolving values, interests and rights. None of the cases concerning gender identity in Strasbourg have involved non-binary status and the claim for recognition, or indeed specific positive obligations to give effect to particular legal repercussions. And you can't simply jump from statements about gender identity in the male-female context to an assumption or a conclusion that they automatically apply in the same way to non-binary. Another step, another conclusion, another set of issues, and another consensus that would be needed, both in relation to non-gender as a legal status more generally, and in relation to the legal and practical consequences of that. Secondly, and coming to the circumstances of the individual appellant, both the judge and the Court of Appeal were, we submit, highly sensitive to and placed entirely appropriate weight on the personal impact and potential impacts on this appellant. And we make no criticism of either of the courts below in that regard. Judgment of the first instance judge, Jeremy Baker Jay, at 107, to 108 and 113, Court of Appeal in particular, see 46, 59 and 123. Thirdly, it is important and relevant, as both the judge and the Court of Appeal also did, to have regard to the true nature and extent of the impact on the appellant of the actual measure that they challenge. There is no disadvantage to the appellant or to non-binary people in terms of that is asserted in terms of employment, benefits, pensions, civil partnerships and so on. None of that. The claim is limited to X on the passport, and the judge was right to hold the appellant to the logic of that challenge. See in particular the first instance judgment at paragraphs 113 to 115, and being, as he put it, less convinced about the true extent and nature of the impact when one views the challenge in that relatively narrow way in which it's been presented. See paragraph 115 in particular. And the Court of Appeal essentially agreed with that approach and that analysis. See paragraphs 55 and 59. There is no, or there has been, as far as the evidence tells one, no victimisation or harassment based on the marking that the appellant currently has in the passport. See the appellant's second witness statement at paragraph 32. It is said that the appellant is aware of harassment and difficulties that have been faced by others, but it's at least seriously open to question whether the placing of X on the passport would solve that. And in any event, to the extent that harassment occurs in third countries, that's not something for which we can be held accountable. And there are two real species of prejudice that are advanced. The first under the heading materially false declaration. And the short submission we make in relation to that is that it shouldn't be overstated as a point, although of course there's an essential and basic truth to it. Our submission is that the judge at paragraph 115, and the points that he made there are well-founded. He found as a fact that it wasn't necessary for the appellant to make a false declaration as to their gender identity, and it is gender identity that is dealt with on the forms, even though the language is old-fashioned in the passport and uses the word sex. In the absence of an applicant selecting one of the two gender options, the gender shown on the source documents will be transposed into the passport application. But we note in that respect and acknowledge the Court of Appeal's judgment at paragraph 58, and we do not seek to challenge that. Secondly, and it's a feature that my learned friend sought to place more emphasis on perhaps orally before this court, the importance of the passport as a form of identity and the fact that that flows from that, which is that there is at least discomfort because you are actively presenting an inaccurate gender when you use the passport for broader purposes. Again, this is a relative issue. No doubt, and no one would seek to deny on this side of the court, the passport can be used as a form of identity documentation. It might be thought that normally when it's used outside the specific context of checking at airports and so on, where computer checks may be done, it may be thought that in those circumstances, most of the time it's used in other contexts, it will be by way of looking at the photograph, so a photographic identity document. Highly unlikely in day-to-day life to be using that as something where you need to look at the MF page, as it were, for the purpose of the identification. And that is a feature which goes to the true degree of or extent of prejudice. In any event, as I've already noted, the passport, even if you did get to that page, still uses the old-fashioned language of sex rather than gender, so might be thought that perhaps adventitiously you haven't got, as it were, a current full-blown assertion of gender. Perhaps most significantly in relation to this, we do respectfully submit that one needs to be very cautious before saying this case is on all fours with B and France, which was a case that my learned friend sought to place some reliance upon. The position in B and France was, on the facts, that the applicant could not change her forename. See paragraphs 56 to 58 in B and France. It's 56 to 58, my lord, sorry. She couldn't change her forename, and the applicant's birth sex was revealed to the world on almost all of her documentation. See paragraph 59. She was therefore unable to conduct her life, including her economic life, in any meaningful way without, in effect, outing herself as trans. And that situation, we submit, is exponentially and obviously different to the position that we are dealing with here. So some real caution before saying there's B in France and there's a directly equivalent position. As I say, no one denies that in some circumstances passports are used for identification purposes, but query whether one has the same degree or anything like the same degree of prejudice that would be involved in the, no doubt, sense of embarrassment of, as it were, perpetually outing yourself in that way. So our broader submission, and can I just finish this point and then we're done for lunch, and I've got, I think, only a few short points to make after the short adjournment. But our overarching submission in relation to this fourth and final aspect of the Strasbourg balancing factors is that there may be some prejudice, as the courts below correctly acknowledged, and we don't dissent from, but it's at the lighter end of the scale, and it is fundamentally non-comparable to the sort of prejudice that was being suffered in by trans people in cases such as Goodwin. We note finally in relation to this that on the very specific question of X on the passports, there is at least some question as to how widely that would be taken up, which is perhaps some indication of the true extent of prejudice, as it were, in this sphere for those who are non-binary. The evidence in relation to Australia, for example, which introduced X on the passports, is dealt with in Miss O'Neill's statement, second statement, at paragraph 24, which is in page 481 of the bundle. And the evidence is that since introduction in 2003, only 141 have been taken up. And Lords, that might be a convenient moment to break.
Yes, thank you, Sir James. We'll adjourn now and resume at 2 o'clock.